Welcome everyone. Thanks again. Like I said, thank you to Community Futures for having us and hosting this. And thank you to all of you for being here today. So today's topic is COVID bills are due. What's it going to look like moving forward? And so we were just talking a little bit about, the whole situation with COVID. The CERB is going to be ending September 26th. So there has been that extension, but it's going to stop at some point. People have kids maybe going back to school or having to make that decision of one parent staying home, maybe in homeschooling or doing that online schooling, which again is going to affect our finances. 40% of Canadians feel overwhelmed by their debt before the pandemic. 43% of Canadians would be in trouble if their paycheck was delayed by 1 week. This is prior to the pandemic. And 34% of RSP holders cash their RSPs in before the age of 71 or before, and 20% of those used it to pay off their debt. So I guess that's just sort of the why. Why are we having this conversation today? And this is why, CERB is ending. We've got to figure out whether one parent is staying at home for the kids to go to school or not. And there's all these other factors. And so I really wanted, the big takeaway I would love to share today is that if you are struggling financially with debt, with your small business, you are definitely not alone. And there are options, there are solutions, there is hope. So, dealing with debt, the fact is at some point, like I said, the benefits and deferrals are going to end. Lenders are going to go back to their usual practices of, collecting on debt, maybe sending you to collections agencies, putting in judgments or liens against the property, looking at foreclosure statements. I mean, that regular activity is coming back. When you come face to face with your debt, which may have been mounting over the pandemic, it's going to be a shock to the system. So what are the things that you can do and when should you start? These are some of the things we want to look at today. So let's start with assessing the right option for you. What are the options that are out there and how do you figure out what's the right option for you? So I'm going to talk very briefly about the orderly payment of debt, which is only available in Alberta and a couple of other provinces in the East. We're going to look at consumer proposals, bankruptcies, and then doing nothing, really just sort of being that deer in the headlights, being in that shock. Maybe, if you think about if you're on thin ice and you hear the ice crack, our first instinct is to just freeze and not do anything. And that does make sense for the first couple of seconds, but eventually we've got to get off that ice. So, we're going to look at all of these options and what does that mean? What does each option look like and what does it mean? What impact does it have? So first of all, orderly payment of debt, like I said, it's offered in Alberta, Saskatchewan, and Nova Scotia. In Alberta, it's offered through Money Mentors. Some of the key, the key features of the orderly payment of debt is you are paying your creditors in full. Whatever the total amount that you owed your creditors, you're going to pay all of it back on an average of 4 years to pay it all off. And it's at a fixed interest rate of 5%. So this is a government, like a provincial program that's available. There is no stay of proceedings. A stay of proceedings is, a legal action that stops your creditors from garnishing your wages, taking you to court, putting a lien against. So these are not available. A stay of proceedings is not available in the orderly payment of debt. And if you go through the orderly payment of debt program, it will remain on your credit report for 3 years after you complete the program. So 4 years for the program, 3 more years it's going to stay on your credit report. So really important that we understand, kind of have that high level overview of what an orderly payment of debt looks like. A consumer proposal. This is a repayment plan. It is subject to creditor approval, but it's not like a wedding proposal. How you get down on one knee and propose and hope that they're going to say yes. It's a forced settlement. The creditors do have to accept the proposal that is made to them. It is a proposed amount. It's not the full amount that you owe the creditors, and there are calculations to figure out what that amount's going to be, and to make sure that it is more than what would, be available to the creditor in a bankruptcy situation. In a consumer proposal, though, you do actually get that stay of proceedings. You get that legal protection from your creditors, and they cannot contact you, send you demand letters, do a judgment against you, or any of that. All of that has to stop once you sign into a consumer proposal. So you do have protection from legal proceedings from your creditors. You must be able to make your monthly payments for a minimum of 3 years. It can be as long as 5 years, as short as 3 years. You can actually pay it off in full. And given the current pandemic, what used to happen is if you were to miss 3 payments on your consumer proposal, the consumer proposal would be null and void. All that interest would come back, and you would probably be forced into a bankruptcy. But given the current pandemic, the Office of the Superintendent of Bankruptcy has allowed consumer proposal clients to, maybe amend the terms of their consumer proposal or look at deferring some payments. So, it's a good, safe place right now, which is really great. Startup administrative fees can, in some cases, be higher than a personal bankruptcy. Not at Bromwich and Smith. We don't actually have any startup fees in either consumer proposal or bankruptcy. It does allow you to keep most of your assets. Actually, none of your assets will vest with the trustee when it comes to a consumer proposal. And it is going to stay on your credit report for 3 years after you complete the program. So let's say, again, the program is 4 years or 5 years, however long you take, plus it's going to remain for 3 years afterwards. And the big thing about a consumer proposal is consumer proposals can only be administered by a licensed insolvency trustee. This is a federally regulated debt forgiveness program, only administered by a licensed insolvency trustee. So there are other companies out there that are really doing a great job on financial coaching and education and all that great stuff. Sometimes they will make it seem, they'll allude to the fact that they can do the consumer proposal for you. They're being an intermediary. The only people that can actually administer a consumer proposal is a licensed insolvency trustee firm. So then personal bankruptcy. And again, a licensed insolvency trustee is the first one to say that a personal bankruptcy is for sure the last resort. What is the definition of a bankruptcy or the bankruptcy process? Well, it's a legal process. It is regulated by the Bankruptcy and Insolvency Act. And it allows you to be discharged from your debt. Now, in some situation, there is some payment that is required, but essentially it is really debt forgiveness. And it is intended for the unfortunate debtor, an honest and unfortunate debtor that's just not able to pay their debts as they come due. And I think more and more of us are kind of, coming to grips with that and coming to maybe see ourselves being in that situation given the current pandemic. So then there's the do nothing. So in the do nothing, of course, you can wait till later if there's nothing to lose. If you've got any assets, this is not a viable option for you. You can consider the risks of doing nothing, which are, your lenders may start to garnish your wages. They may seize your property. As this pandemic and all of the benefits start to lift, we're going to start to see more of lenders taking those actions. Doing nothing could lead to lots of annoying and, almost threatening calls from collections agencies as well. So, I really wanted to give everyone an opportunity to kind of look at what are the different options that are available to you, either as a small business owner or just as a personal person when it comes to looking at your debt. And then we're going to get into a little bit more detail here. So what about your creditors? Your creditors have some legal rights as well. Once government controls are lifted, creditors are going to go back to exercising their rights. So let's look at what do those rights look like for creditors. So your creditors it depends on the type of credit that you have with them, okay? So if you have a secured contract, so a loan or a line of credit that is tied to some sort of collateral or has a cosigner on it, then your creditors legally can seize the property, they can sue you, or they could do both. So that's really important to know. So let's think about like a car repossession. Actually, car repossession in Alberta is really not the best one because they really can seize or sue. But if you look at, okay, like your house is a secured credit. So they can seize the property, foreclose on it, sell it, but then they can also sue you for any shortfall, the difference between the sale of your home and what was owing on that mortgage. So that's a seize and sue situation for a secured credit. Now, there are conditional sales contracts. So this is like those, you know, if you think of those like rent to own furniture places and things like that, those are conditional sales contracts. So in that situation, the creditor can either seize the property or sue you, but they can't actually do both. So they either come in, take away the big screen TV and the sofas and kind of leave your house empty, or they say, listen, keep all that furniture. It's not really worth anything to us, but we're going to sue you for it. But they can't do both. And then finally, there are unsecured credit contracts. And this is the majority of the credit products that most Canadians are going to have. It's going to be this type of a credit contract that you're going to have. It's an unsecured credit contract. So this would be like, you know, your credit cards, utilities, you know, most loans would be considered an unsecured credit contract. And in that case, again, your lender can stop the service, they can begin collection process, and they could sue you. So this is the area, the unsecured credit contract is the area that we're going to really focus on, because that's where your options of insolvency can really come into play. Oh, and finally, you know, in terms of how are they going to do it, you know, they can use letters of demands, they can go to a collection agency, and a collection agency is under no obligation to actually accept your payment or apply the payment to the debt. So we have heard horror stories where people will say, I've already paid $3,000 to this collection agency, and now this other collection agency is calling me about the same debt. Unfortunately, it can happen, and it does happen. So what happens if your creditor sues you, okay? The creditor needs to file a claim in, you know, at the Court of Queen's Bench in most cases. And then you're given 15 to 20 days to file a dispute. Now, let's be really honest. Most of us don't open that piece of mail that feels like it's a bill or a threatening letter. I mean, me included, been there, done that, right? We don't open this type of mail because it scares us, it's frightening. But then we're passing up on this opportunity to dispute. And even if really, truly, you're like, I know I owe this money, but even just going and disputing could buy you a little extra time and some negotiating room. So this is really important to know. If there's no dispute, the judgment goes through, it's posted against you at the court. The creditor will file what's called a writ of enforcement to proceed with action to collect from you. So that can include wage garnishment, bank account garnishment, or a lien against your property, or seizing your property. So this is sort of the process of suing, and again, what the rights would be once, you know, there's no dispute and the court goes ahead and grants, you know, your creditor the ability to sue you. So what are your options? You know, you can look at reworking your budget. And I know budget, it's like that dirty B word. We have a blog coming out here soon and a CTV segment talking about finding the joy in budgeting. And I will tell you, you know, I've been doing a budget since my very, very first job. And I find it so freeing. I look at this Excel spreadsheet. It's very non-emotional. It tells me what bills are an absolute must, what my, you know, free fun money is, and I just do what my spreadsheet tells me. I plugged in everything on my spreadsheet, of course, but it just takes away all of that emotion for me. And then when something comes up, like the, you know, let's say my sister says, hey, we want to go on a trip for the long weekend, I'm not weighed down. I can just say, hey, sorry, that's not my budget, but you guys have fun. I found a joy in it, and I really, really hope that others can find joy in doing a budget, or don't even call it a budget, call it a spending plan. And, you know, you want to make sure you build in some fun money, or else it's just like a diet, right? If you don't build in some cheat time, you're not going to stick to that budget and you're going to end up binging, right? So in terms of a budget, you want to calculate what your basic living expenses are, track where your money is going right now. You want to get a baseline of your budget before you make any changes to it at all. So I do recommend, you know, do a 3-month period where everything goes through on that debit card so that you can track every single penny that goes out of that bank account and where is it going and what are you doing with it? Because quite often, you know, if we've got cash in our pocket, we don't necessarily get the receipt. We don't really know where it went. Or you can do like the jar system or the envelope system. There's lots of different things online, but you want to get a baseline first of all and figure out where you're at. I have a friend, I remember when, you know, so it's a couple and their 2 kids, and the first time we did a budgeting session, you know, they go to Starbucks quite a bit. The kids are in ballet and horse riding and all these different things. And so Starbucks is kind of, you know, their go-to, sometimes even for dinners or just, you know, on the way to practices and stuff. And so his estimate of what they spend was about $75 a month. When he did this baseline looking at the bank account for 3 months, it turned out they were actually spending $400 a month at Starbucks, and no judgment there at all. You, for yourself, just need to decide, hey, if this $400 at Starbucks is a non-negotiable, but at the end of the month, there's more month than money, then we got to work on something else. So this is not, and I think that's where we sometimes, you know, neglect doing a budget because we think we're going to get a slap on the wrist or some judgment. This is for you. This is by you. Really, truly, every budget is as unique as every individual. So just do it. Get a baseline, figure out where you are at so that you can find ways to either increase income, decrease expenses, or maybe even do a combination of the two. And you can really talk, you know, you can talk to someone at Community Futures about ideas on how do I increase my income, or ideas on where do I start with decreasing, you know, the money that's going out. And I know, you know, when I have struggled in the past, I was like, there's nowhere to cut. And then sometimes when you get a different set of eyes, you can find a place to cut. And so I will admit to that for sure. Another option might be to refinance. If you've got, you know, let's say you've got a mortgage and there's some equity in that home, there is an opportunity to take out more money, to tap into that equity and then extend how long you pay. Now, nothing is for free. There is a cost benefit analysis that you've got to do here. You know, what is that interest rate? What is the total amount of interest I'm going to pay over the term of this new loan that I'm going to take? And does it make sense to take out a 30 or 35 or 25-year mortgage for this thing that I want to refinance for, you know? And maybe it is for your debt. That can be an option, or you really want to make sure it's a one-time thing. You don't want to be using your home as an ATM machine or as a consolidation loan generator for you, right? But it could sometimes lower your payments. Or you got to look at whether a refinance really is lowering your payments and lowering your interest rate, or is it actually a little bit more interest, and is it really moving you ahead? Is it really moving you towards your goals? Another option is a consolidation loan. Now, a consolidation loan is where, you know, a bank that you deal with is going to say, okay, so we're going to take this credit card, this line of credit, this loan, this other credit card, we're going to pay them all off and put all of those balances onto this new loan. So it's not like the debt just goes away. It gets consolidated into one loan, one payment. Sometimes it's a better interest rate. A lot of times it's not. Again, there's so much shame and stigma around this topic that quite often Canadians are not going to seek help with a legitimate source like their bank or a licensed insolvency trustee. You're kind of going online. There are a lot of trolls online. There are a lot of consolidation loans that are specifically geared towards and created for the credit challenged. And because you're hiding behind a computer screen, it's really easy to kind of go down that rabbit hole. So you really want to make sure, if consolidation loan is the way you want to go, it's got to be a better interest rate and lower payments. And it's got to put you in a position where you can pay the debt off faster than if you had left it as it was. Okay, what other options do we have? You could look at borrowing from friends and family. And I can't see you all, but I'm wondering if you're cringing when I say that. You know, to me, that's a warning sign if you're going to friends and family for help. And I just, you know, it needs to be done above board. If you're going to borrow from friends and family, I would say put everything in writing, have very clear conditions and terms of conditions in place. And also really important to know, if you are the family member that's helping somebody out, when you co-sign for a loan, I think quite often we feel when we co-sign, what we are saying is, hey, yeah, Joe's good for this. What you're actually doing when you co-sign is, listen, Joe's probably not good for this, but it's okay. I'm going to pay for it. Most people don't think about that when they co-sign. So just, if we're going to do the friends and family thing, I think it's wonderful if you actually have friends and family that are willing to help you out, or you're going to be that person. Just make sure your I's are dotted, your T's are crossed, and things are very above board, and that you understand what you're getting yourself into. Another option is you can negotiate directly with your creditors, especially right now as we come to we're still in this pandemic, but as we're coming to the end of the CERB benefits and the deferrals, this is a really great time where I feel like the creditors are still willing to come to the table and still willing to negotiate. So that is an option. I would say before you talk to your creditors, do your budget, figure out what you can afford. You know, if you're kind of like, hey, I'm in the red $500, I got to reduce my payments by $600 or $700 a month. Okay, so I'm going to go to my creditors and say, listen, I can afford payments of $200 a month, or whatever that may be. But make sure that you kind of have a game plan in place of what you can afford. Keep your communication open with the creditor before it starts to get to that collection point of view or stage. They're much more willing to negotiate with you when you're still kind of making your payments on time, or maybe you've missed one, but you're not really late and really chronically being late, or in that position where they're looking at, you know, sending you off to a collection agency. And then be sure that you get an agreement in writing before you start making payments on that settlement that you've agreed on. So don't wait, start now. That's a big message for me for you. I want to talk a little bit about the very last option, which is bankruptcy. And I know we don't love to talk about it, and that's why I'm here today, so that we can talk about it openly and get our facts. There are a lot of myths out there on the internet, on YouTube, in, you know, editorials and blogs, and just within our friends and family. So I just want to set the record straight here today so that you can make the most informed decision that's best for you. So bankruptcy does give you a stay of proceedings, which means legally your creditors can no longer send demand letters, garnish your pay or your bank account, or send you to a collection agency. A first-time bankruptcy is usually a 9-month process with monthly income and expense reporting. You're required to do the 2 financial counseling sessions. During the bankruptcy, there may be a GST rebate or income tax refund, which will automatically be forwarded to your trustee and applied towards the debt or the administrative fee. Now, sometimes what happens though is that money comes to the trustee just around the time that you are being discharged from your bankruptcy. And so I can't speak to other trustees, but we have made sure that that money goes back to our clients, because every penny counts when you're at this stage, when you're at that bankruptcy stage. A really cool fact to know is that your universal child benefit and child tax credits will continue to be received by you, because those are for your children. They're not for you. They don't have to sit with your trustee. So that's a really big benefit, or just a good thing to know. Again, with a bankruptcy, there's no charge for a consultation. So, you know, to pick up the phone and have a free, no obligation, very personalized and confidential consultation, the only cost to you is your time. There's a basic administrative fee. I can clearly remember a time where I was getting calls from a utility company, and I'd been in a really bad car accident. I was 100% commission. There was literally no money coming in, and I'm bawling on the phone saying to this, you know, this utility provider, there's no way, I might have to declare bankruptcy. And on the other end, she says to me, well, if you can't pay this bill, you can't even afford to go bankrupt. And I thought I was going to have a nervous breakdown. It was just like, what do you do when you're in this situation? Well, it's true. There is a cost to doing a bankruptcy, and the maximum cost is $1,800 over 9 months, which is $200 a month. Kind of straight across the board, all trustees will charge that $200 a month. At Bromwich and Smith, we charge $179 a month. If there's no blood to be squeezed out of a stone, there's no blood to be squeezed out of a stone. So I'm going to say that there are fees. It is important to pay those fees because it's really the only way that the trustee gets paid in a bankruptcy situation, and that every situation is unique. There are lots of trustees that are willing to waive that fee if that makes sense. So don't let that stop you from contacting someone and having that conversation. I don't know of any, lower price solution for you if this is where you're at. Again, the remainder of the fees, if there's any surplus income or anything like that, it'll be adjusted. GST rebates and things like that would go directly to the trustee to cover the rest of their admin fees. And there can be an extension of time to pay these fees if that's available and if that's necessary. So again, bankruptcy is the last resort, but let's have a look at the fact that, again, there's a myth out there. If you file bankruptcy, you're going to lose your home, you're going to lose your car, you're going to have no assets at all. And there are 4 principles of the Insolvency Act, and one of them is rehabilitation. It's being able to rehabilitate yourself to be in a good place financially. So if we take everything away from you, there's no room to rehabilitate, right? There's also another principle is faith in the system. And as North Americans, as Canadians, we are a credit-based system. And so we need to have faith in that system. The only way we can have faith in a credit-based system is if we have an exit strategy to deal with when credit gets really, really bad. So I just wanted to share with you that in Alberta, you've got exemptions for clothing and personal effects up to $4,000, furniture and appliances, $4,000 per person, a vehicle, you can have up to $5,000 worth of equity in your vehicle without, having to hand in that vehicle or having to refinance or trade it in for a vehicle that has less equity in it. You can also have up to $40,000 of equity in your home, in your principal residence. Anything that is registered retirement savings plans, RESPs, RIFs, life insurance policies that have a named beneficiary who is an immediate family member, all of those things are 100% exempt. The government doesn't want us stealing from our future selves to pay for our past situations. And so the government is protecting those things from your creditors. And usually when we're trying to deal with it on our own, the first thing we're going to do is liquidate these things. So don't do that without having a conversation with someone, because those things cannot be touched by your creditors. So why should they be liquidated by you to pay your creditors? And then there are tools of the trade as well. So any type of business or work activity allows up to $10,000 of tools of the trade. And this is specific to Alberta. The exemptions are different in each province, but I know you guys are all right here in Alberta today. So the above exemptions only apply if it is an unsecured credit. This is where the Insolvency Act comes in with unsecured creditors and unsecured credit. If there's collateral, it's really different, and actually it isn't open to insolvency. You'd have to look at some other options there. But again, give us a call and we can walk you through that. Equity is just the difference between the amount that you're owing and the value of that item. So if we look at equity in your vehicle, you owe $3,000. If you were to sell the car, black book value is $4,000. You've got $1,000 worth of equity in your vehicle. It's really important to look at where you bank. The bank has a right to seize your bank account. They have a right of offset is what it's called. It's in that really tiny fine print when you first open your bank account with them. So what that means is, let's say I'm with ABC Bank. I'm not going to use real bank names. My checking account is with them. My savings account is with them. My TFSA is with them. My loan and my credit card are with this ABC Bank. If I am not making my payments and they've done everything they can, they have every right to start seizing money that comes into my checking account to pay that line of credit, to pay that credit card, to pay my overdraft. And it just happens. There's no letter, there's no warning. They just have a right to do that. So I will share this slide deck with the team at Community Future so that you've got all of these websites that I'm suggesting that you look at and learn your rights and learn just the kinds of things that you need to do to protect yourself. So let's talk about your credit report. That's another big myth that is out there. If I declare bankruptcy or a consumer proposal, my credit is ruined. I will never get credit again. My credit's going to be horrible for 7 years. So we'd already talked about, orderly payment of debt, consumer proposal. Those all are 3, 4, 5-year programs, and everything remains on your credit report for 3 years after. So the total is 7 or 8 years on those options. And everyone thinks that on the bankruptcy side of things, it's much, much worse. It's really not that much worse. It's quite similar. So a bankruptcy shows up, the rating of a bankruptcy on your credit report is an R9. The other options are an R7. So consumer proposal, orderly payment of debt, any of those things are an R7. A bankruptcy is an R9. So that is a worse rating. It will remain on your credit report for 6 years after you complete your bankruptcy program. So first time bankruptcy is 9 months, and then it's going to remain for 7 years after you discharge. A second bankruptcy is going to remain for 14 years, and a third bankruptcy, unfortunately, will never go off your credit report because it's clear that you haven't been able to rehabilitate and get back into credit society. Anything that is placed in collections, or if there's a judgment against you, it has basically the same rating and lasts on your credit report the exact same amount of time as a bankruptcy. So that's a big, eye-opener, I think. So quickly, I want to tell you a little bit about Bromwich & Smith so you can get to know us and what makes us a little bit unique. Our motto is rebuild your worth. And Suze Orman has this awesome quote that says, when you understand that your self-worth is not determined by your net worth, then you will have financial freedom. And let's be honest, I have definitely been there when I have been at rock bottom and my finances just are so horrible. It absolutely affected my self-image and my self-worth. And so, at Bromwich & Smith, we really want to help you rebuild your self-worth as well as your net worth. We're a team of licensed insolvency trustees and debt relief specialists committed to rebuilding our clients' worth while helping them to persevere through these challenging financial times. I'm going to share with you what our purpose is. Our purpose is to relieve that overwhelming financial burden that individuals are experiencing in accordance with Canadian legislation. And we are an eco-friendly organization that's committed to making a positive impact on the lives of those that we assist, employ, and do business with. And how do we do that? We treat everyone with grace plus respect. So this means that we are non-judgmental. You are going to have empathy, kindness, professionalism, and courtesy when you're dealing with us. 2, we're providing impartial plus unbiased information and commentary. If you go to our website and have a look at our tools, our YouTube channel, our blogs, even our segments that we've done in the news, it's very impartial and unbiased information. It's not, hey, come declare bankruptcy at Bromwich & Smith. It's really about informing and allowing Canadians to make the most informed and well-educated decision. 3, fostering diversity of individual perspective. So not only in terms of our workplace are we diverse in our gender and our culture and our perspective, our openness to have dialogue, also in terms of how we serve the Canadian population, and that every Canadian has their perspective. We will make a recommendation, but the ultimate decision is up to you, and we are here to support you with that. And then finally, providing a library of resources to support that continuous personal growth and understanding. And again, if you go to our website and you look at our tools, our blogs, our YouTube videos, our webinars, you're going to see a wealth of resources, not just from Bromwich & Smith, but also from other community partners that are financial experts. So our vision is that we become nationally recognized as the leader for people needing debt relief. We want to accomplish this by recognizing the social and emotional challenges of debt, providing efficient and effective solutions, and being a compassionate organization that people are comfortable referring their friends and family to. So you think about, when you've gone to a great restaurant, or you've seen an awesome movie, or you just read a great book, we refer our friends and family to that all the time, right? What made you tell them about that restaurant or encourage them to buy that book? It was that level of service. It was the engagement. It was that feeling of, it was those good feelings, right? And so that is what we are fostering at Bromwich and Smith as well. And a referral is really the biggest compliment we can get. This is really key. These are our core values. They don't just sit on a wall somewhere in our offices. We live, breathe, and eat these. We read them at the beginning of all of our meetings. We share stories that relate to our core values, either where we've done a really great job of living by our values, or where we've maybe dropped the ball somewhere and we need to do some work. So I love being part of an organization where our values are not just a piece of paper. So what our values are is that, we operate with the highest level of integrity and ethics and honesty in all aspects of what we do. It's really, really key to us. We strive to earn the trust of our stakeholders with every interaction we have with them. We develop long-term relationships based on knowledge and understanding with a caring and sensitive approach in all that we do. We're adaptable and embrace change for the betterment of all stakeholders. Wow, has there ever been a lot of change with this pandemic? We've sent most of our staff to work from home. Not only are we serving our clients by the phone, but really everything that we used to do in person, we now do through video. So it's from the comfort and safety of your home. Our goal is really to serve 1,000 digitally comfortable Canadians, in the next 5 years going forward. So we're really excited. And 1,000 per month is what I was trying to say there. We recognize and encourage individual responsibility as a means of empowerment. When you are in a consumer proposal or a bankruptcy, there's a lot of responsibility placed on you as an individual, and it is meant to empower you. You are not a victim, you are a victor, and we want you to feel like a victor as you go through this process. And then finally, we're an organization of individuals with diverse skills and interests, opinions, cultural backgrounds, which really strengthens our collaborative team. What we do at Bromwich and Smith, we administer the consumer proposal as only licensed insolvency trustees can, as well as bankruptcies. And then we will refer out to reputable partners for credit counseling, debt management programs, orderly payment of debt, and other education and tools. We refer out to Community Futures quite a bit, actually. So how do you get a hold of us, and what does that first contact look like? There's a toll-free number anywhere in Canada that you would call into, and you would speak to one of our lovely debt relief specialists who will treat you with grace and respect, with a lot of empathy, non-judgment, and really give you that impartial and unbiased information. In this call, and I would say it's about a 20-minute call, we're going to figure out, are you insolvent or are you not? If you're not insolvent, we are going to refer you out to one of our trusted partners, whether that means refinancing your mortgage or doing something different with your vehicle, or going to talk to somebody at Community Futures to just help your business get back on track. So if you're not insolvent, we're doing that. If you are insolvent, the debt relief specialist is going to go through with you bankruptcy versus consumer proposal, and then make a recommendation based on your income, your expenses, your assets, your liabilities, your dependents, your marital status. All of those kinds of things are going to come into play in terms of making that recommendation, ultimately your decision. Then they're going to prepare the file, set up a virtual appointment from this really, really cool app where you're going to meet with the trustee like this, and they're going to bring up the forms that you need to sign. And when it's time for you to sign, it's going to show up on your little smartphone, and you're just going to sign it, and then it's going to pop back up on the screen. It's super, super cool, and really, truly very safe in terms of your privacy, and very safe in terms of COVID. You get to stay in the comfort and safety of your home. It also speaks to that stigma and shame, right? You're not sitting around waiting in, the reception area, worried about who else is going to walk in and maybe see you. Once you're signed into one of the programs, you've got that legally binding stay of proceeding, to protect you from your creditors. And then you're going to start to rebuild your worth and, get that sense of relief and hope. Just a little bit of bragging rights. We've won a few awards and been nominated for a few awards. So I wanted to share that with you. And then just finally, these are all the different ways that you can connect with us. We are on Facebook, Instagram, LinkedIn, YouTube, all of the social media channels. So what do we need to do next going forward out of this webinar today? Well, you want to find out who and how much you owe money to. This requires doing a budget to determine what your ability to pay is. And then once you've got that, once you've figured out who all do I owe money to, what is my budget, then reach out and have a consultation to really figure out how do we get out of this bind. It may not be as bad as you think, or it may be that it really is bad, but we can help you and you can start to rebuild. So that's really my whole presentation. I'd love to open it up now to any questions, comments, and then I'm just going to leave on the screen for a little bit just my contact information if you want to jot that down. Of course, Community Futures is going to be sharing the whole presentation with you all, so you'll have the whole entire presentation. But if anyone has any questions, I'd like to open it up now to that. I'm not sure if we have any in the chat box. Otherwise, you can just feel free to unmute yourself and ask away.
I was just wondering, if you had a client who, okay, let's say it was a credit card. The credit card company's calling all the time, and that is it the credit card company that sends that letter of for them to pay? And then if I say no, I want to go with you guys, then you guys would send that orderly payment of debt letter saying, hey, stop contact, or?
Okay, so let's clarify a couple things. The creditor is definitely going to contact you when you're owing them money in lots of different ways. Okay. Yes, they'll send letters, they'll make phone calls, there could be demand letters. They could send you to a collection agency. Now, if they've done that, it's not the creditor contacting you, it's this third-party collection agency contacting you. So yes and no, the creditor might contact you, but if they send it to a collections agency, then it's actually the collections agency contacting you. Again, at Bromwich and Smith, we don't administer the orderly payment of debt program. That's through Money Mentors. But as far as once you sign into a consumer proposal or bankruptcy, it's the licensed insolvency trustee through the legal process that basically lets the creditors know that this is what's happened and that all information, all contact has to be directed now directly to the licensed insolvency trustee firm. There's often a lag there. So I do want to put a little bit of a caveat that, we have had situations where someone signed in today and tomorrow they've gotten a phone call and, they'll call us up in arms. There can be a lag, there can be a delay. And what I would say, if that happens to you, just let them know you need to talk to my trustee directly, and then call us and let us know, hey, I just got a phone call from ABC Bank, so that we can make sure that it gets put into place. And give us that little bit of time. It doesn't necessarily happen immediately right when you sign. Great question, Suzanne. Those are really good questions. Thanks.
I was wondering, the writ of enforcement, that's a legal one that you would have to do through a lawyer? Like as a creditor, I'd have to go to a lawyer and do that one, correct?
Yeah, through the court. Through the court. It's actually a legal process that you have to apply to the court, and then the court will grant that writ. So yes, that requires legal fees, and it is a legal process, and it can be time consuming.
Sounds like everything's a little time consuming.
Right? Exactly. So I mean, and I guess what you can say about that, yes, creditors have deep pockets, but this is why they're going to take every other action they can before they go down that route. This is why you're going to get those annoying phone calls. Why are they still calling me? Why do they keep sending me letters? Because they're going to try and exhaust every alternative that they can before going down that road of seeking that legal writ or that legal lien or whatever that may be, because that has a time cost to it as well as a money cost to it. And if I could also just add in, sorry, the time to take action is at that, when you're getting those annoying phone calls and letters. I mean, ideally before that, But then that is the next time. You know how they say, what's the best time to plant, you know, an apple tree? It was 100 years ago. When's the next best time? Today, right now. So the best time is before they start contacting you. But the next best time is when they start contacting you, but before it goes to a collection agency, or before they actually put that lien or start that foreclosure process, because then our hands are really, really tied. Not as tied with, you know, if you're dealing with a collection agency or even garnishing your wages, but I mean, just save yourself that trouble and get in contact with us before all of that starts happening, because that's where, you know, when I talk about that thin ice and you freeze, the minute someone starts taking that little bit of money that you have out of your bank account, you have fallen through that hole. You are in freezing cold water. I don't know how deep you are, but that, like, nobody needs to be in that situation. Don't put yourself in that situation. Get in touch with us before that happens.
So would you say that if you were in a problem like that, would be go talk to the bank first, and then if they're not able to assist, then reach out to someone more qualified for answers, really?
Yeah, definitely. If you're not at that point where you've had a lot of lates and they're chasing you down, your lender or your bank may be willing to still negotiate with you and work something out. So for sure, start there and have that. It's really about communication. And quite often when we're in these situations, I can attest to it. I have been there and done that, where I've just buried my head in the sand and just, you know, not open the news, open the letters that come, not answer the phone calls. And if I were to go back and do it again, that's the one thing I would change, is just, I wouldn't wait for the phone calls and the letters. I would call my bank first and go, I am drowning. This is not working. I don't want to declare bankruptcy, so let's work together. I would use that for sure. But if you're not successful there, then the experts in the community on debt are your licensed insolvency trustees. It's just like with the pandemic, we turn to the health minister. We're not looking at your local doctor or your, you know, specialist. We're talking to the health minister. That's the right expert. In the debt situation, the right expert is your licensed insolvency trustee.
Awesome. Thanks, Taz. That was awesome.
Oh, well, thank you guys. I would just want to say kudos to Community Futures for kind of being the trailblazers and having these conversations. I know, again, there's a lot of stigma, shame, there's a lot of myths around this, but as we as a community start having these conversations and start to normalize this, we're going to be able to empower more and more Canadians to be able to make those really informed decisions for themselves. So I am going to pass along my presentation. If anyone wants to chat with me one-on-one or with the firm, you know, you'll have all of our contact information. Oh, and we've got one last quick question. Go ahead, Thea. I think she's gonna have to type it in. So, and somebody, oh, Suzanne, you said you're gonna watch for that that CTV segment about finding joy in budgeting. I know, I'm excited for that one too, because it's just this like.
Well, just to watch it so that you know how to talk about it to clients and to other people, because like I have a lot of younger nieces and nephews that are getting into that working stage and need that help. So it'd be something that they like YouTube. So here you go, watch it over here and go from there.
Exactly. Oh my God. And to start them young, to just have, like I say, like I just started, I was 16 when I had my first like real job. And I swear to God, to this day, it is still just an Excel spreadsheet. I don't do anything fancy, but it works. And it's a habit that was created since I was really young. And I'm so grateful. But I think, I can't remember the exact stat, but it's something like 95% of Canadians don't have a budget or do a budget, you know? So if that's you, you're not alone. But let's start creating some joy around it. Okay. What kind of resources do small businesses have to recoup unpaid bills to their business? Oh yeah, that's flipping the question. Great question, Thea. So I guess that would relate to, you know, what I talked about with like, what are the creditors' rights? It would be those sorts of things that, I mean, you're a small business. It really depends on what kind of contract was in place. But quite often, even a small business will have the right to do things like seize or sue, maybe do both. Most likely as a small business, there's going to be an expense to you to get that set up, whether you want to send something to a collections agency or really appeal to the court. or seize some property that maybe, you know, they've bought from your store but have not paid for. I would recommend talking to 2 people on this if that's your situation. I would talk to your accountant for sure. And then I would see if you could do, you know, a bit of a free consultation with a business lawyer, ideally someone, you know, like specifically in your type of business. At least get that free consultation. And then there's a lot of really great resources online, I would say, as well for that. Really good question.
Yes, awesome. Thank you, Taz, again. And I look forward to another one when we get another one planned, and we'll just keep sending these out, and hopefully we hit more and more people and help them all out.
Awesome. Thank you so much.